Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today we discuss Pung versus Isabella County, decided June 23rd, 2026, 9-0.
9-0, and right there, the simplicity ends. Because what looks like a clean sweep actually fractured into three separate opinions. Justice Alito wrote the majority. Justice Sotomayor wrote a concurrence. Justice Thomas wrote a concurrence in part. And the lineup matters.
Because Justice Thomas refused to join a key section of the majority opinion, and because three justices who voted with the majority immediately turned around and wrote separately to limit what they just signed onto. This vote didn't function as a unified 9. It looked more like 7 votes on the core ruling and 2 signal flares pointing in different directions about what comes next.
One decision, several fractures.
Exactly. And as you may recall from our preview episode, we flagged the gut punch facts behind this case. A Michigan family fought a disputed tax bill twice, won both times, and still lost their family home of 27 years. Today, the court answered the constitutional question. For now, the government wins, but the Pung family may not be done.
Before we go further, follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
All right, here's what you need to know. Picture a modest 3-bedroom ranch home in Union Township, Michigan. Scott Pung bought it in 1991 for $125,000, raised his family there. His wife Donna Marie lived there after he died. Their son Mark moved in after Donna Marie passed. 3 generations, 1 house, nearly 3 decades.
And they pay their taxes, every bill, in full. Michigan taxes primary residences at a lower rate than second homes. The Pungs qualified, paid exactly what they owed every single year.
So what went wrong?
In 2010, the local tax assessor decided, incorrectly, that the Pungs no longer qualified for the primary residence rate. She denied their exemption for tax years 2007 through 2011. The family challenged it in the Michigan Tax Tribunal, Michigan's specialized tax court, and won.
They beat it.
Then the assessor did it again. She reimposed the same extra tax for 2012, totaling $2,241.93. And she did it after the original tax bill already went out. The Pungs never saw the extra charge on their statement.
And it's pretty insane how they found out. Executor Michael Pung showed up at the township office with a check for the full printed amount. A clerk stopped him, told him about the extra charge. Michael pushed back, brought his cousin Mark in with a driver's license to prove primary residency, paid the original bill, refused the extra charge.
And the assessor's reaction to the court that already ruled against her.
Justice Thomas quoted her directly in his concurrence. She said, and absorb this, I don't care what he says. That quote runs through this entire case like a thread. Remarkable.
And when the county's attorney stood before the Supreme Court in February 2026, Justice Gorsuch asked point blank why the county pursued a $2,242 debt that its own tribunal found the family didn't owe. The attorney admitted on the record that the county couldn't explain the assessor's reasoning.
Extraordinary. The county declared the estate delinquent, launched foreclosure, a trial court blocked it, Michigan Court of Appeals reversed. A state court entered a foreclosure judgment in 2015. The trial court then vacated that judgment, concluding the Pungs likely received no notice and stood ready to pay the moment they learned of the delinquency. The county appealed that ruling too.
The Pungs appealed the order that would have saved the family's house. In June 2018, after 27 years of family ownership, the Michigan Court of Appeals permanently stripped the Pungs of their title. All over a tax 2 courts found the family likely didn't owe.
And what did the county get at auction?
The county's own assessment valued the home at $194,400. It sold at public auction for $76,008, less than 40 cents on the dollar. Less than 18 months later, the auction buyer flipped it for $195,000. Almost exactly the county's own assessed value. The county initially kept every dollar of the proceeds.
So the family lost roughly $118,000 over a $2,242 bill they probably never owed. That's the human story. Keep that in your head for the rest of this episode. Michael Pung sued in federal court under 2 constitutional provisions, the 5th Amendment's Takings Clause and the 8th Amendment's Excessive Fines Clause. The federal district court handed him a partial win on the 5th Amendment claim, entitled to the surplus above the tax debt. That surplus, $73,766.07. No fair market value. Eighth Amendment claim rejected.
The Sixth Circuit affirmed. Bound by its own prior precedent, when the government sells a home at a properly conducted tax auction, the former owner gets the surplus and nothing more. And then the Supreme Court stepped in. Granted certiorari, the formal term for agreeing to hear a case in 2025, argued February 25, 2026, decided June 23, 2026, vacated and remanded. Break down the legal question.
Two provisions. The Fifth Amendment's takings clause reads, "Nor shall private property be taken for public use without just compensation." That phrase, just compensation, drove everything. The Pung family said it means fair market value, what a willing buyer pays a willing seller on the open market. Same standard the government uses when it clears out a neighborhood to build a highway.
And the county?
Tax foreclosures follow a different centuries-old tradition. Under that tradition, just compensation means the surplus above the debt and nothing more. And the Eighth Amendment?
The excessive fines clause bars excessive fines. The Pung family argued that grabbing a $194,400 home over a $2,242 debt and selling it for $76,008 amounted to a grossly disproportionate punishment.
A fine, basically. A very large, very one-sided fine. And here's the tell. At oral argument, Justice Sotomayor challenged the family's attorney to name a single court in 250 years of American history that measured tax foreclosure damages at fair market value rather than the auction price. And?
He couldn't. He admitted no such holding existed. That exchange told you exactly where the court would land.
The majority's reasoning rested on one pillar: history. Justice Alito went back all the way to Magna Carta. English and American law, for centuries, let governments seize and sell property to collect tax debts. The condition, return the surplus, the overplus as the old texts called it, to the former owner. Surplus, not fair market value.
How far back does that tradition run?
Think founding-era statutes. An 1812 federal law required surplus returns from Washington, D.C. tax sales. An 1815 nationally applicable statute demanded the same, surplus of the proceeds of the sale after satisfying the tax, costs, charges, and commissions. Maryland in 1797. North Carolina in 1792. Massachusetts in 1785. The founding generation drew the line consistently. Surplus, nothing more. And the court's own cases back that up.
4 big ones. United States versus Taylor, 1881. The government owed only the surplus after selling a property worth far more than a $70.50 tax debt. United States versus Lawton, 1884, explicitly grounded the surplus rule in the Fifth Amendment itself. Nelson versus City of New York, 1956, recognized the surplus right, noted it could yield to reasonable state time limits. And BFP versus Resolution Trust Corporation, 1994, rejected fair market value as the measure for a foreclosure sale entirely.
So what did the Pung family argue against all of that?
They leaned on eminent domain cases. When the government builds a park or runs a pipeline through your land, it owes fair market value. Same rule should apply here.
Intuitive argument.
The majority rejected it. In eminent domain, you did nothing wrong, and the government simply decided your land served a public purpose. Tax foreclosure runs differently. The property owner can generally avoid the sale entirely, refinance, sell the house yourself, borrow against the equity, and pay the bill. Justice Alito pressed the family's attorney hard at oral argument. If you carry $190,000 of equity and owe $2,000 in taxes, can't you just take out a loan against the equity and pay the debt before the government touches the house?
And the Pungs didn't have a clean answer.
No. Then the majority ran the math to show why the Pung rule collapses in practice. Hypothetical: $100,000 home, $20,000 tax debt, $60,000 auction price. Under existing law, government keeps $20,000, returns $40,000 surplus. Under the Pung rule, government owes $80,000, $20,000 more than the auction ever generated. The government loses money collecting taxes.
The Solicitor General, who argued as a neutral, called it the end of tax sales in America, and the majority agreed. Pung's interpretation, if correct, would have eliminated a practice that survived hundreds of years of constitutional scrutiny. Strong evidence, the court said, that he got the constitutional text wrong. Eighth Amendment claim fell on the same logic. No history supports it, and the fair market value rule would would destroy the tax sale system just as surely through the 8th as through the 5th.
So the split was 9-0, 9-0. Just compensation after a tax foreclosure sale runs to the auction price, the surplus above the debt, not hypothetical fair market value, at least when the government conducts the sale fairly in light of the nation's history. The Sixth Circuit gets vacated. Case remanded.
Why vacated and not just affirmed?
Because the Pung family raised procedural arguments at oral argument. Whether the county needed to pursue personal property before seizing the home, whether historical notice requirements got violated, that the Sixth Circuit never addressed, those arguments return to the lower courts. The door stays open.
Now here's where the decision gets genuinely interesting and where that 9-0 framing gets complicated.
The concurrences?
3 separate writings, 3 layers of internal disagreement. Start with Sotomayor.
She joined the majority and then wrote separately?
She did, joined by Justices Gorsuch and Jackson. Her message, the majority's phrase, fairly conducted in light of our country's history, does not define what fair actually looks like. That question stays open for the lower courts. Don't read this opinion as freezing the fairness standard.
So, 3 justices voted with the majority and immediately walked back part of what they joined. Sotomayor, Gorsuch, and Jackson refused to let the majority's language foreclose the fairness inquiry. If you're Isabella County, you don't walk away from this decision claiming total victory. You won round 1. Round 2 happens on remand, with at least 3 justices already signaling the fairness question stays wide open.
And then, Thomas. Justice Thomas wrote the most powerful opinion in the case. He concurred in part and concurred in the judgment, agreed the Sixth Circuit needed to go, but refused to join Part 2B of the majority opinion. That's the section where the majority dismissed the Pung family's counter-arguments on the merits.
He thought the majority used history selectively. Exactly. He argued you don't get to invoke the historical tradition to protect the government's tax sale system while ignoring the parts of that same history that protected homeowners.
Same point Gorsuch hammered at oral argument. If you invoke history, you eat all of it. You can't cherry pick. Gorsuch put it memorably. You've got to eat your coulis. That's a reference to Thomas Cooley's 1876 treatise on tax law, the same treatise the majority cited for the surplus rule, which also contained the personal property first requirement and the sell only what you need rule.
2 historical limits the majority passed over.
2 limits Thomas put front and center. First, before seizing real property, a home, land, the government historically needed to exhaust the debtor's personal property first. Bank accounts, vehicles, goods. Thomas traced this to Magna Carta. For a $2,242 debt, the county could have gone after a car. Instead, it went directly to the $194,400 house.
The family's attorney floated a Peloton bike at oral argument as the example. And Justice Alito fired back. Good luck selling a Peloton for $2,000 on Facebook Marketplace. The room laughed, but the point survived the joke. Bank accounts, vehicles, personal goods all stood available before the county touched the house. Second limit, sell only as much as you need. Governments could seize only so much property as necessary to cover the debt. When a government sold more than necessary, the historical remedy ran to fair market value. Trespass lawsuits for taking too much.
Thomas used that to build a clean argument. Fair market value didn't function as the constitutional baseline, but it served as the remedy when governments overstepped. He called what the county did to the Pung family wrong and, in his initial view, likely unconstitutional. The government exists to protect property. Property does not exist to support the government.
Now here's the detail that stopped me cold when I read this opinion. Gorsuch joined Thomas's concurrence, except as to footnote 1.
A footnote.
A footnote that explains why Thomas joined the majority at all.
Right, and that's the tell. Footnote 1 carries Thomas's stated rationale for joining the majority in part.
He wrote, he joined because he agreed the auction surplus can constitute just compensation if consistent with historical practice, and because he agreed the parties deserve an opportunity to litigate below whether the county's conduct met that standard. 2 premises.
Gorsuch refused to sign onto either one.
What does that signal?
It signals Gorsuch may not view this as an open question needing further development below. Thomas's footnote frames the historical analysis as something the lower courts still need to work through. Gorsuch wouldn't put his name on that framing. The most natural reading, Gorsuch may already view the county's conduct as indefensible under the very history the majority cited. He doesn't need to call it provisional. He doesn't need to say, let's wait and see.
So Thomas signed the letter and explained he signed it provisionally Gorsuch signed the same letter but refused to sign Thomas's explanation.
which suggests to Gorsuch it isn't provisional at all. And remember, Gorsuch also joined Sotomayor's concurrence, which kept the fairness question open for the lower courts.
So Gorsuch operates in a very specific space in this opinion. He agrees the county's conduct likely violated the historical rules. He refuses to frame that as a pending question. And he simultaneously wants the lower courts to develop the fairness standard without constraint from the majority's language. That's a lot of daylight from the majority, carved out almost entirely in footnote 1 of a concurrence.
3 opinions, 3 fractures, and the most revealing one came in a single footnote.
Justice Barrett captured the human picture at oral argument. She compared the tax assessor to Inspector Javert, the relentless pursuer from Les Miserables, then added it was even worse because Jean Valjean hadn't stolen the bread. The Pungs never owed the tax.
So at minimum, Thomas and Gorsuch both signal the county may not survive scrutiny on remand, and Gorsuch may view the outcome as even clearer than Thomas does.
At minimum, 2 votes, possibly 3, with Sotomayor keeping the fairness question open.
This 9-0 decision contains the seeds of a very different outcome in round 2.
Let's get into what this actually means. What actually changes after this ruling?
For homeowners with tax debt, hard truth confirmed. If you fall behind on taxes, the government can foreclose on your home, sell it at auction for far less than market value, and return only the surplus above what you owed. The Constitution after today demands nothing more, at least not as a blanket rule.
And the scale of the problem reaches far beyond Michigan. Amicus briefs documented it. A West Virginia owner's $65,000 property sold for $2,700 to cover an $80 tax lien. A Baltimore owner's $140,000 property sold for $5,000 to cover a $2,500 lien. In Washington, D.C., the average property sold through a tax lien fetched $17,400, while the average tax-assessed value of those same properties ran to $578,100. After today, those former owners can't point to the takings clause and demand fair market value.
But they can challenge the process itself.
They can. The court opened that door without walking through it. Sotomayor's concurrence tells lower courts the fairness standard remains undefined. Develop it. And Thomas wrote the roadmap: personal property first, sell only what you need, rigorous notice, competitive auction procedures. A future plaintiff who builds those arguments at the trial court level may well bring a case back to this court.
For state and local governments, today's decision preserves the tax sale system, but don't read it as a green light for the conduct Isabella County engaged in. At least 2 justices put that conduct in their crosshairs. The Pung family doesn't get fair market value as a constitutional right today, but they go back to the Sixth Circuit with an open record and a detailed roadmap from Justice Thomas. This fight doesn't end here.
Let's land it. 9-0. Auction surplus satisfies just compensation. The Eighth Amendment adds nothing. Sixth Circuit vacated, remanded.
But that 9-0 vote fractured 3 ways. 7 justices on the core ruling. Sotomayor, Gorsuch, and Jackson writing separately to keep the fairness question open. Thomas writing separately to argue the county likely acted unconstitutionally under the very history the majority invoked. And both Thomas and Gorsuch declining in whole or in part to join the section that dismissed the family's arguments.
This decision protected a centuries-old debt collection system, and it planted the seeds of a much bigger confrontation over what a constitutionally fair tax sale actually requires.
The government exists to protect property. That principle may yet matter for the Pung family. Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
And look, if Isabella County can sell your $194,400 family home for $76,008 and the Supreme Court gives them a pass, the least you can do is leave us a 5-star review. That one cost you nothing.
Talk to you soon.